Welcome to the INREM podcast, where we discuss the law for real estate investors. Andy and Sean are both attorneys. Nothing said in this discussion should be considered legal advice. We're simply providing information and education. You should consult with an attorney in your state regarding any specific legal issue that you may have. Good morning, everybody. Thank you for joining the show today. Today, we're talking about business succession planning. I'm Andy Fowler, and I'm here with Sean St. Clair. If you're new to the show, give us a like. Make sure to subscribe to our channel. You can find us on Facebook. You can find us on YouTube. Go to our YouTube channel, hit like, subscribe. We appreciate your help and your follow. With that, we're going to go to Sean, who's going to give us our legal update for today.
Yeah, so today I want to talk about the difference here in Arizona of formal versus informal probate, and kind of explain when you would use each and the timing and processes for each of those proceedings. So the first one is informal probate. That's the probate that we prefer. If we can do a probate and we have to do a probate, then we're going to want to do the informal probate. And what that looks like is you file the paperwork with the court, and the Superior Court has a probate registrar. So it's a person who's responsible for reviewing the probate packet to determine whether or not everything's in order and the probate qualifies for an informal proceeding. And so, assuming that everything checks out and the case qualifies for an informal proceeding, the judge will then sign your letters of appointments and all the other documents needed to appoint somebody as personal representative of the estate. And then that person from that point forward has the full power and authority to act on behalf of for the estate. There in an informal proceeding, there will not be any hearings. Basically, the personal representative is tasked with performing all of their duties and responsibilities outside of the supervision of the court. But once they complete all their tasks, they can file a closing statement, which will then result in the informal probate being closed. Now, if there's real estate involved in an informal proceeding, that property can be sold fairly quickly. So if you file with the court an informal packet, and you're here in Maricopa County, which is the largest county in Arizona, the court generally will approve that packet within a matter of days. And then from there, the personal representative can either enter into the contract, or if there's already a buyer that they know of that wants to purchase it and is ready to purchase it via cash or otherwise, then they can basically sell it to that buyer the day after they're appointed. And you just deliver the paperwork, the certified paperwork, to the title company, and then you can sell the property. So that's an informal proceeding. A formal proceeding is one in which the probate does not qualify for the informal process. And so from there, you basically are looking to have a court oversee the process, have the court review everything, set a hearing, and then decide if they should appoint whoever's applying to be the personal representative of the estate. Now, once they're appointed, they can step in and do everything that they could do in an informal proceeding. The problem is that initial hearing takes time. It's normally about 60 days from the time that you file the application to the date that you're going to be able to be in front of the court and have the court determine whether or not you can be appointed. The situations, and this isn't an exclusive list, but the common situations that result in having to do a formal probate are the person dies without a will, and there's a number of individuals who, by our statutes, have equal priority for appointment. So, for example, if a parent dies and they're not married, they're unmarried, but they have 3 children. So let's say they die, they're not married, they have 3 children. Those 3 children would have the equal right to appointment. Well, if they cannot get along and agree to file a packet and have all 3 of them appointed at the same time, or if 1 or 2 of them aren't willing to waive their right to an appointment so that 1 of them or 2 of them can be appointed, and so there's some dispute as to who should be appointed, who should be in charge, then it's going to have to go to a formal probate. The same as if there's a will and they appoint somebody, multiple people by the will, which kind of gets back into some drafting techniques. When I'm drafting wills, I kind of recommend, hey, 2 at the most, preferably 1, because we don't want these disputes. We want, the informal probate if we can have it. But nevertheless, let's say they appoint 3 people by the will, and they can't get along and agree to jointly file a packet, then it's going to go to a formal proceeding. Or let's say there is a will, but not the original. Let's say that they find a copy of the will. Well, a copy of the will means formal probate. You can't go informal and say, well, there is no will. Well, there is, because there's a copy. But you don't have the original, which is a requirement to be in informal proceedings, so you would have to go formal. The other reason that it would go to a formal probate is some form of disagreement between the parties as to the distribution of assets, between the validity of a will. Maybe there is a will, but one of them says, oh, well, that was executed under suspicious circumstances, right? There was undue influence. There was they didn't have capacity. It was towards the end of their life, and they had been diagnosed with some condition that would affect their capacity, and so they dispute it. Then it's going to go to formal probate, so disputes. But if it's just if you have the original of the will, no dispute amongst the parties, and clear and definitive personal representatives who are all on board to be appointed jointly, then you can go the informal probate. Otherwise, you have to go formal probate. Once you're in formal probate, it's full supervision by the court. So even after that initial hearing, the court's going to set a status hearing and will follow the case all the way through. And then in order for you to close the probate, you have to go and apply and obtain court approval to close the probate when it's formal as well. So the preference is to be informal. It's a lot less, it's less expensive, it's more efficient, and that's the preferred method of probate. But formal, you can still accomplish the same objectives. It's just going to take a little longer and be more expensive.
I think what a lot of people don't appreciate with the what takes so long with a probate, or a formal probate, I should say, versus an informal. And it's really because of due process, right? I mean, there is a potential dispute, or there's a potential contest over a priority of appointment. So the way the courts set these hearings is really designed around the ability to give these other parties that have, under a will or under statute, the right to receive notice of all of that. And that's, so it's not just, well, it's going to always take long because there's a fight. A lot of this just has to do with due process and notice. With that, all right, we're going to go to our some in-rem news. Today, Sean and I, with the in-rem podcast, we're going to be live just like we were last month. If you were following us a month ago, we're going to be live on site and live streaming from the Buy and Hold meetup on October 25th. Well, tonight. So starting at 4:00 p.m., the location will be at the Scottsdale Area Association of Realtors. Sean, why don't you tell our audience who can come?
Yeah, so anybody who wants to come can come. Basically, it's a free event, but primarily the individuals that are coming to the event are those that are interested in real estate and real estate investing. And as the title of the event is, it's buy and hold. So you have a lot of individuals that are interested in holding or do hold vacation rentals, regular long-term rentals, and other properties that they've invested in, and they're holding them for, a longer period of time than just, a fix and flip. They're not, the event is not focused on wholesaling, although there are a number of investors that show up who do wholesaling. But it's basically for real estate investors, and with a focus, and the topics are focused on buy and hold. But in addition to real estate investors, you'll find hard money lenders, you'll find mortgage brokers, you'll find real estate agents, you're going to find attorneys. So, we regularly attend the event. There's other attorneys that attend the event as well. And so there's a large mixture of different professionals that are working within the real estate space or the real estate investor space, as well as investors that show up and attend the event.
Who's speaking tonight?
So speaking tonight is, and you may have to help me out because my computer's glitching a little bit, but I think it's Andrew LeBaron.
Yeah, that's
okay,
correct.
perfect.
Andrew LeBaron speaking.
Yeah, Andrew LeBaron is speaking at the event, and he's talking about how to manage and secure vacation rentals during a shifting market or a recession. And so that's going to be a really interesting topic. The market is changing, whether for the good or bad, I don't know, but it is adjusting. We all know that. Whether that constitutes a recession, or we're going to see depreciation like we saw back in 2008. Who knows? But it's still good to keep your eye on it and figure out, okay, how do I take advantage of any shifts or changes in the market?
All right. So what are we going to be doing there? So we're as the NREM podcast, Sean and I, we're going to talk to Andrew, the Andrew LeBaron, the speaker at the event. He's going to be telling us a little bit more about what he's doing, what he's going to be talking about at the event. We'll be talking with guests. So if you're there, you want to come and talk with us, ask us some questions, feel free to come down. We'd love to talk with you. We're also going to have a question and answer segment, an opportunity for you all to pose legal questions to Sean and I about real estate investment topics. So if you're in the area, we'd love to have you. If you can't be here, we're live streaming. It's going to be available online live. So you'll be able to participate that way as well. It'll be a great event. Looking forward to seeing you, whether that's in person or virtually. With that, let's get into our topic today. We talked a little bit about this last week, and talking about business divorce and the ways in which changes to your business or divorce or events that cause a wedge in your partnership, it can create a problem for you as a real estate investor. And at the end of that, we got into kind of the highlights of what's known in the legal community as business succession planning. So today we wanted to give, and we've danced around this topic on a variety of different shows, but we wanted to give a more in-depth treatment of business succession planning, what that looks like for you as the real estate investor, what that looks like on this side of the aisle for the lawyer, and what goes into those considerations. So to start this out, wanted to talk about just generally in summary fashion, talk about the events that result in result in the need for business succession planning. There's certain events in life and in business that tend to cause this. So I'll summarize some of those, and then we're going to get into each one of those specifically. The first one we see this a good bit, but it's the sale of a business. You've been in business for some time. That is oftentimes the goal with every business, is to find some sort of endpoint. Sometimes the endpoint is that you are in it until the day that you die, but a lot of times it's to build it up, to get it, to build your investment up to its highest value, and to sell it. So event number one is usually the sale of a business, is something that you're going to want to be planning for and thinking through on the front end. And that's kind of your first event. Number two, voluntary or involuntary disassociation. Disassociation is a term that the Arizona revised statutes provide. And we'll get into different events that can be voluntary or involuntary. What other events do we have, Sean?
So the other events that we have would be death. So an owner dies. Another event would be disability. And then another event, and this isn't always a succession event, but nevertheless, divorce is an issue. So if you've gone into business with one spouse and the other spouse really hasn't, doesn't have an ownership, hasn't been involved, but they go through a divorce and the ex-spouse is awarded, or the member spouse is awarded a ownership interest in the company, well, you may not want to be in business with the spouse. And so you may want the ability to basically purchase or buy the spouse's interest. So that's another type of succession. And then another one, and I think, honestly, this is one that most closely held businesses or small businesses overlook, which is retirement. The idea that most businesses, the retirement plan is their 401k.
Yeah, right. I think most people, when they think about retirement, they just think about the money they set aside in the bank or the retirement account.
Right.
Their business, which is itself an investment, oftentimes gets completely lost in the mix, right?
Right. Yeah. And for me, I think a successful business is one that, or a successful succession plan is one that considers retirement and what that looks like. When can members retire? After they've been an owner for how long? 10 years, 15, 20, 25 years. And then what does it look like? How are they, does the business continue to compensate them? Do they sell their ownership interest? What does that look like? But most of the time, that's not something that's dealt with on the front end as far as, business planning and succession. And I think it's something that, most small businesses need to start looking at. Obviously, if it's just you that owns the company, it's different. But if you have partners and members, employees, it's something to start thinking about.
Well, and to the extent that they do think about it, oftentimes it's with the assumption that the only retirement plan is the full outright sale of the business, and you're receiving some giant cash lump sum. We know in our own experience and with the experience of representing other businesses, that's not what it has to look like. It can look that way, but it can look a variety of different ways, and we'll get into that. With that, this is a good opportunity to talk more specifically about that first event that we discussed, the sale of the business. So Sean, let's talk about specifically kind of what that looks like and what investors want to be thinking about as they plan for that.
So when we talk about the sale of a business, we're talking a few ways to accomplish the objective. And the first way to accomplish the sale is your asset purchase. And that's where you basically identify all of the assets of the company or the business, and you sell those assets to another company. So if you have a limited liability company that's operating as a going concern, then you basically take those assets and you sell them to another limited liability company who then will operate the business. But checking accounts will not transfer, EINs will not transfer, payroll will not transfer. The new owner, if employees are going to go to the new company, the new owner will have to put everything in place to continue to operate the business utilizing those assets. Now, why would you want to transfer your assets versus do like a buyout of the ownership of the business? One would be the buyer may want to buy the assets because they want to take the assets only. They do not want to assume or take on any of the business's debts or liabilities. Now, you have to be careful to avoid, successor liability issues. You have to be careful to avoid fraudulent transfer issues, because you, as a buyer, to avoid having to continue to pay those debts, and it's only unsecured debts, right, that you can avoid. But in order to avoid those debts, you have to be a bona fide purchaser for value. You can't pay less than fair market value for the business. Otherwise, that could be a factor or a badge of fraud for a fraudulent transfer claim.
Sure. Well, and even in cases where the debts have been paid or there's not any debts to speak of, usually the asset purchase agreements, because they just don't want the general baggage of what might have come with the prior owners, and that can include taxes.
Mm-hmm.
That could include employer-employee liability with employees. Those things. Sometimes those events can occur between employer and employee. Well, they can occur at any time, but it could happen in the middle of an escrow on the sale of a business, and you really not even know about the claim until after the fact. So sometimes it's just to shed the baggage of a company run by somebody else that you don't know, going forward.
Yeah, exactly. I mean, there could be debts that you're not aware of, personal injury claims, and, claims by employees for, wrongful practices, that type of thing. So you're right. It's just to basically take it clean and, get rid of any baggage that's out there. But the logistics of an asset sale are more complicated. Most businesses operate under a name. And so, since you're not taking on the LLC, normally the name is going to mirror the name of the LLC, right? The name that they're operating under. So then you're going to have to take the rights of a trade name, and you're going to have to then register a trade name so that you can continue to operate the company under, that prior name. So there's a number of things to consider, but an asset purchase agreement is one way to, sell the assets, and you can do it either in cash, or you can do it through seller carryback financing. And, my only caution is, and I've seen this, unfortunately, where you do seller carryback financing, and there's not really reporting requirements. So you want to make sure you have reporting requirements by the new owner, where the new owner stops paying. The reason they stop paying is they've run the business into the ground. So even though it's seller carryback, you come back in and take over, and you don't have anything to really take over. And then you're just out that money, and they've basically taken your successful business and ruined it. I mean, that happens. So you have to be careful on the seller carryback. But it's something that can be done. The other type of sale would be your membership interest or your stock sale. So if it's a limited liability company, it would be a membership interest purchase, and in a corporation, it would be a stock sale. You're going to sell your shares of stock in the company. In that case, you can keep everything the same, right? The EIN will be the same. The bank accounts will be the same. You just have to, change signers. The payroll can be the same. You can use the same payroll company. You don't have to set up new payroll. You don't have to do anything. The POS systems are the same. All of that is going to be the same. One thing you have to look out for in a membership interest purchase agreement is existing leases. While the lease may be under the name of the company, a lot of times in commercial leases, it's going to say a full or a 50% or majority ownership transfer in the underlying company constitutes a transfer for purposes of the lease that requires the landlord's approval. So you have to look into that. And so that's something to consider if you're going to, if the company has a space that they're leasing, you have to make sure that if you do buy it, that you can continue to lease that space, and you're not causing a breach or a default under that commercial lease.
Yeah, that is, in my experience, a big one. For one reason or the other, in the buy and sale, even it can even happen in the asset purchase agreement context. There is a commercial lease out there, and its assignment provisions are always landlord friendly. They almost never give a tenant the unfettered right to assign that lease. And so there's a variety of different things that happen, and I think most people think, "Well, it's not a big deal. I built my business up. They're gonna agree to it." And oftentimes they do, but there's a lot of things at play. There's the lease, there's the personal guarantees that you've signed. Oftentimes the landlords, they're in a pretty strong leveraged position. You're selling your business. That doesn't mean that they have to agree to let you and maybe your wife or your husband off the hook, as the case may be, if they're on a personal guarantee. So, in my experience, a lot of times that's left towards the end to negotiate, and sometimes that really holds up the deal.
Yeah, the commercial lease, if there is one out there, is a huge consideration and something that needs to be dealt with on the front end. I mean, I've seen people sell the business and be like, "Well, we'll figure out the lease on the back end." It's like, no, that needs to be dealt with on the front end. Another way to sell and or buy a business that I think is unique um, would be to enter into basically a management agreement with an option to purchase. So a lot of times you don't really appreciate or understand the inner workings of a business and how successful a business is until you actually get in there and get your hands dirty, right?
Right.
And so one option would be, hey, I'm interested in this business. And this is kind of right up my avenue, right? Because I love creative financing and real estate. And so one way to do this with a business would be to enter into a management agreement whereby you agree that you're going to step in and manage the business, and you agree that you're going to pay so much to uh, the business, which will then, be considered profit to be distributed to the owner. So ownership doesn't change. Ownership doesn't change, but you agree, hey, monthly, quarterly, however you structure it, I'm going to write a check to the business for this amount. But then everything else I get to keep. Or, instead of writing a check, you basically just hold back from the profit a certain amount that you guarantee to those owners or to the company, which then is distributed as profit to the owners. You guarantee that every month or every quarter, and then you receive the profit. And you have a right to do that for, a year, 2 years, 3 years. But then you also have an option to purchase, so that if you get it in there and you realize, hey, this is great, I'm doing well, I like it, I'm running it well, the company's doing well, that type of thing. Then you can have the ability to purchase it via that option. And so at that point, you're locked in. You know that you have that right. The right to purchase it exists. The buyer knows you have that right. But maybe not the buyer, the seller knows you have that right. But maybe the seller of the business, um, they just don't want to run it anymore, but they want that, ongoing revenue stream. And so they bring in that, trusted person to manage it, or that potential buyer to manage it, so that they can see if this is something that they want to do. And so that's another interesting way, or unique way, creative way to sell a business, but allow the buyer to have kind of a look to see if this is a good fit, for all parties involved.
Sure. So how are you we can talk about back and forth how we might structure this, but how are you looking to typically or seeing these deals structured?
Honestly, my preference is to do the membership interest purchase agreement, or the stock
Mhm.
purchase. I mean, if I had my druthers and, you know, it looked like a clean transaction with not a lot of debt, with not a lot of issues, not a lot of liability exposure. To me, for my clients, I think that the membership interest purchase is the most efficient.
It's much more turnkey.
Yes, it's so much more efficient to be able to just walk in and be like, I'm the new owner.
Mm.
I'm now operating this, and I don't have to go and set up bank accounts. I don't have to figure out payroll. I don't have to do, new EIN. I don't have to deal with the POS system. Sometimes you have contracts with third parties. Well, now you got to update all the vendors as to, who to make the checks payable to, right?
Right.
So you have to do all of that. There's a number of things that have to be updated and adjusted and changed, and it's a lot of work on the front end versus if you just buy the membership interest, you can just step right in and operate that business. And hopefully the business was being operated in. That's the other important part of succession is you want to operate your business in such a way that if you were to be out on the street tomorrow and somebody had to step in, they could basically just seamlessly take it over. And, whether you want to do this or not, our firm is going through a little bit of a transition right now, right? I'm stepping away from the management of the firm come January 1. And so you'll still be one of the managers, but I'm having somebody replace me in my duties and responsibilities. And through that process, what I'm learning is that I know a lot and everyone else knows a little about the areas of my duties and responsibilities.
Sure.
And so if something were to happen to me, like there'd be a huge mess and learning curve because
The learning curve would be a straight line up.
yes, exactly. Because, I know where I saved everything. I know where I drafted everything. I know where I stored everything and all, and how I did everything, but now I'm training somebody to do it. And what I'm realizing is even if you don't replace yourself in your business, in order to figure out if your business can survive you, you should find somebody that you can train to do your job. And then you should step away, which I did in June. I did not basically step foot in the office. And anytime anyone reached out to me, I said, nope, talk to the person who is going to be my replacement, because I basically said, you're in charge in June. And they ran everything in June, right? And so that allowed me and us to figure out where we needed to improve. So come January, it's a much smoother transition. But I stepped away. I was gone for a month. Can you step out of this is the question as to whether or not your business is in a condition that it can be sold or that succession can happen is, could you step out of your business for 30 days and that business run and not fall apart and somebody else does your job? And if you can't, you better start training somebody now to make that happen, even if they're not going to replace you, but just so that you can make sure that you're operating the business in such a way that succession can in fact happen.
And that's really at every level, every level of the business, right? From ownership down. I remember, to give the credit to Natalia Grice.
Yeah.
Grice, she said, what was it? Systems make or break a business. That's
Yep.
basically your systems.
Right.
And if you can't, whether it's because you've sold or because somebody's died, if they can't just pick that up and go, your systems weren't great.
Right. Yeah.
Let's talk, while we're talking about the sale of a business, whether it's by asset purchase or membership interest. And of course, we're using the term membership interest because most businesses are LLCs. It would be a slightly different document if it were a corporation. But let's talk about how we typically see these financed. Obviously, if you got the cash, you got the cash, and that's a somewhat easy transaction. But what are the other ways that you would document that?
Yeah. So if you're going to do some form of seller carryback financing, like I mentioned before, where generally the buyer is going to put some money down, but they don't have it all. They don't have the full purchase price. And so they're going to agree to pay you over time. In that case, what you're going to want to do is you're going to want your payment to generally come from the company or from the operations of the company. But you could also have them come from the buyer. That would be fine as well. But you're going to want a promissory note. And that promissory note is going to be guaranteed by the opposite party, right? So if the company is the one that executes that promissory note to you for the purchase, then you're going to want it guaranteed by the buyer and their spouse. If the buyer is the one to execute the promissory note, you're going to want their spouse to execute it as well, just to be safe. Although a promissory note, may not be subject to community property protections, but nevertheless, you want the buyer and the spouse to execute that promissory note. And then you want the business to guarantee the payment under the promissory note. And then you're going to secure that promissory note by some form of collateral. Generally, and you can ask for additional collateral, but generally the main collateral will be the assets of the business, which includes, its goodwill, its accounts receivable, cash on hand, personal property. Basically, the business as a going concern, you're going to secure that and all of its assets via a security agreement. Basically, a security agreement, for those that are watching that are primarily involved in real estate, and you understand what a deed of trust is. A security agreement is basically like a deed of trust, but for personal property. So you use a security agreement to secure a lien against personal property, and then the security agreement or your lien is perfected by the filing of a UCC-1 financing statement with the Secretary of State's office. So that's kind of like the county recorder's office for real estate. The Secretary of State's office is for personal property. And so you file a UCC-1 with the Secretary of State's office and you secure it. Now, you can also provide other types of collateral. So it doesn't even have to be associated with the business. You can say, hey, look, buyer, do you have equity in your home? If you do, give, I want a second or third position deed of trust against your home. Do you have vehicles? Do you have personal property that, has value? I want to secure it against, those. So you can secure it against the buyer's other assets as well if you have any concern about payment. But one thing that you're going to want, and this is where when I used to do litigation, I would see a lot of this on the back end where somebody sold their business, the person runs it into the ground, and they are trying to figure out what to do, or they're not paying. Let's say they're not paying. Maybe they haven't run the business into the ground, but they're not paying. So we take a look at their security agreement, and in my view, it did not have very good. A lot of times those security agreements don't have very good default provisions, and now they're forced to go to court and try to take over the business through the court proceeding. Well, if it's in court, that buyer, now owner of the business, is not going to be as motivated to continue to keep the business going because they're afraid they're going to lose it. So what you want to see is the ability to basically have self-help repossession of the business, right? You want to have that ability where it says you can basically, if they're not paying, you give them 10 days notice. If they still don't pay, you basically can change the ownership documents with the either Secretary of State or the Corporation Commission, and you can step in and take over that business and start to run it, or have a receiver appointed or something like that. Now, a receiver is going to take a court order, so now you're in court, but you want the ability to basically just move in ASAP, and that way there's a limited ability or chance that any further damage can be done to the business by that buyer, now new owner.
Now, one hybrid scenario that a seller looking to sell their business should consider and be aware of, where you're receiving some money upfront as well as a carryback, is, and especially if you're in the real estate context, you might not be used to this, but when you're selling your business, there's a good chance that the SBA might be involved, so the Small Business Administration. And they may be involved in providing the financing. Now, the nice thing about that is, for you as the seller, they're bringing a bunch of money to the table. They're getting financing, so that's a lot of cash to you up front. But I've seen this there with when dealing with the SBA, if there's any portion that's going to be carried back by you, the seller, the SBA puts a lot of limitations on what you can do. They'll allow you to carry that back, but your loan's going to be subordinate to theirs, because let's say it's like a $2 million deal and the SBA is bringing in 1.6 or 1.7 million. Well, they've got the most of the money into this thing. Your note or notes are going to be subordinate to that. The payment obligations are going to be secondary. They're going to heavily restrict you on how you can secure it, if at all, because the SBA doesn't want you as a lender to come in and basically seize the business if they're not paying you when you're owed like 50,000 or 100,000 and they're owed 1.6 kind of thing. So that, on one hand, it's a good thing that they're involved because that provides a lot of the financing. So you're not carrying a huge portion of it, but that's going to heavily restrict what you can do in your rights and remedies under your note and whether you can even do a security agreement. With that, let's talk about voluntary or involuntary disassociation.
Yeah, so voluntary and involuntary dissociation is basically having somebody exit the business, withdraw from the business. Dissociation is a legal term of art that we use here in Arizona. It's found in our Limited Liability Company Act, and it's basically another term for withdrawal or leaving the business. And that can be done voluntary, where somebody says, hey, I just don't want to be involved anymore. I want to pursue other business opportunities. I have other aspirations, and I don't want to be, part of this business anymore. So they can voluntarily withdraw or dissociate. And then the second is involuntary, and that generally happens in two ways. So the first is an involuntary dissociation with cause, meaning a member has done something wrong. They've stolen from the company. They've somehow breached their duties and obligations. They're competing directly with the company and stealing, clients from the company. So clients that otherwise be utilizing the company, they're using them for their other business. They basically are damaging or harming the business. And in that case, you're going to want to have a buy-sell agreement in place that will allow the members, the other members, the members that are not engaging in the wrongful conduct, to basically take a vote and determine that you've engaged in this wrongful conduct, and to, kick you out of the company, basically, strip you of your membership interest. So that's one means of involuntary dissociation. The second is just a member voted dissociation. And so if you own a company 50-50 with another member, that's a little bit more complicated because, you each have a 50% interest. So who's going to be able to vote the other one out?
Right.
I'll tell you how to get around that in a minute. But if you have a majority owner, or you have three people that own a business, then you can provide that, if two of the three of them decide, we can't work with this other person, maybe the person's not doing anything wrong. They just, it's like a divorce. You get married, you're in, love, and, in that honeymoon phase, and everything's going to be fine. And then, a few years later, you're like, yeah, we just don't get along. We don't see eye to eye on things. And, you're not a bad person. I'm not a bad person. It's just, it's just not working out. That happens in business as well. And so maybe two of the three owners decide, yeah, we just can't get along with this person. It's personalities clash. And so it's time to move on. And so they can vote to have that person dissociate or withdraw from the company. And then there's, buyout provisions and stuff like that. Now, what happens in the case that there's 50-50 ownership? What does that look like? One way of working with this is if the owners if they don't get along and there's personality clashes, and instead of ending up with the company just not being able to operate because there's deadlock, you can put a provision in a buy sale that basically states that either member can buy out the other member's interest by presenting an offer to purchase. However, that member receiving the offer has 10 days to turn around and basically buy out the other member's interest, the member presenting the offer, to buy out the member who presented the offer, buy out their interest on the same terms as was presented to them. So that forces that if you have members that aren't getting along, that it forces basically any member that wants to buy out someone else to make them a pretty fair offer, because the concern would be that, if you give them a lowball offer, well, they'll turn around and be like, well, this is a great offer. I won't take it for myself. I'll just buy you out for that offer. I would only have that clause kick in after the members have engaged in some form of mediation. So give them a chance to mediate, to try to resolve their differences. And then if they can't be resolved through mediation, at that point, you open the door for that type of offer to be made.
Interesting. Let's talk about death. That's another event that we've discussed, a big one, and usually an unplanned event, because nobody is planning unless they have the opportunity because of some illness to really think through and plan this out. A good reason why this is worthwhile considering very early on in the formation of the company and how to deal with that. But let's talk about death and what it looks like to transactionally prepare for that.
Yeah. So there's basically three things that I want to see in the corporate structure or company structure. The first is an operating agreement that provides that if somebody transfers their membership interest, including a transfer that results from death, right? Where that membership interest is either going to be transferred to the estate or to the heirs, that the person stepping in is only an assignee of the membership interest unless the other members agree, or supermajority interest of the other members agree to bring them on as a member. And what an assignee of a membership interest means is you only have the right to participate in the losses and profits of the company. You do not have a right to participate in the operations. You do not have a right to vote. And you are allowed access to some financial information, but it's limited to basically establishing the amount that you're entitled to receive on a monthly or quarterly basis, or whatever provisions the operating agreement provides for the distribution of profit, or the allocation of losses. And so you're provided some limited financial information necessary to just determine whether or not you're receiving the amount you're entitled to receive. So that's one. That's in your operating agreement. The second is a buy-sell agreement, which basically provides that the company will purchase or buy out the member's interest based upon a calculation, whatever calculation the parties agree up front, but that they're going to buy out their interest via the buy-sell. And the company's required to buy them out, and they're required to sell. They can't just hold on to the membership interest. So that's number two. The third thing that I like to see is life insurance, key man life insurance, whereby it's an amount sufficient to do two things. Number one, it's sufficient to pay the buyout price to the estate. So the estate doesn't have to worry about, are we going to ever see this money from the company? Can the company afford to buy us out? Because a lot of times the value of the company, or most of the time, right, the value of the company and the value of the membership interest is going to be greater than the cash on hand in the bank of the company, right? The more cash on hand you have, the greater the fair market value of the company is going to be. And it's generally always going to be greater than the cash on hand, because there's other factors that go into determining the value of a company, including, its regular cash flow and its property and operations, assets, goodwill, all of that. And so that doesn't, that's not indicative of the cash available to buy somebody out. So, by having the life insurance in place, you're basically making it so that it's an easy buyout. The company doesn't have to worry about it. The estate doesn't have to worry about it. The money is just going to be paid from the insurance company. But then the second thing that you want from the life insurance is for it to be in an amount sufficient to allow you to replace the owner. Most small businesses the owner works within the business and they're critical to the business. And if they pass away, you want to make sure that you can bring somebody in that can perform their job, and you're probably going to have to pay that person a salary of some amount of to be able to step in and handle that. So you want to make sure you can pay them for 2, 3, 4 years, whatever the case may be, so that you don't see a real drop off in company profits and performance. But once again, the idea of bringing somebody in to replace the deceased owner gets back to what I was saying before, which is you need to make sure that a company can continue to operate and there can be a fairly smooth transition from one owner to an employee or from one owner to someone else should an owner die or step out or have to leave the business. And so death is a perfect situation or example of a situation where you're going to want to make sure that, even if we have everything financially in place, the business may not operate very well because this person knew their job and that was it. Nobody else knew it. Nobody could figure it out, that type of thing. So you want to make sure that for succession purposes that you're training and you have systems in place that allow someone else to step in.
Well, yeah, sometimes the success of a business tracks with the personality of maybe the person running it, just depending on whatever it is. So that person might come with kind of a unique insurable value, so to speak, one that you'd place a high premium on. Now, how do you what do you say for businesses, especially ones that say, "Okay, Sean and Andy, we've taken your advice. We should do this right at the front end. We're 25, a couple partners, we're young, we're gonna do this." They may not die for the next 50 years. And a business is a pretty dynamic thing. What you value a business to be now might be totally different in 50 years, or what you negotiate now is like buyouts and everything. Do you suggest that, like estate planning, that businesses every 5, 10 years relook at their succession plan, whether the buyouts make sense, or do you try to draft it from the front end to deal with that? I think that's kind of hard on the front end in terms of appraising and what that could be worth in the future.
Yeah, I agree with you that every 5 years or so, you need to look at a business. Our law firm's a perfect example. When you and I started, uh, we were working out of some other attorney's office, subletting some space. I was working from home, and that law firm was nice enough to let me use their conference room when I needed to meet with clients. And then we ended up with our own space, but had no furniture. And my personal private office in that space, I put up a card table or a folding table in order to work because I didn't have a desk. And we really didn't have. We were just building something, right? We did not have assets, and so the idea of life insurance, the idea of retirement, the idea of really structuring succession wasn't even in the cards, right? And frankly, if you and I, in the early years of the company, if you and I passed away, one of us passed away, it really wouldn't be a huge setback for the company
Right.
at that point. But as we, started growing and, 5 years in, then we started thinking about that stuff and we kind of restructured financially and did a few things, put in some life insurance in place, had provisions in our operating agreement. We added a buy sale that dealt with, what happens if an owner dies. We added, partners. And so we started slowly but surely transitioning. And then, more recently, we looked back and did a restructuring. And this time we went even beyond death, disability. We actually went into the idea of retirement. And not only retirement, but the idea that attorneys may want to go down to part-time status. and what that might look like, and when they can go down to the part-time, when, the owners of the firm or the equity partners can go down to part-time status, and what that looks like financially for them, and, what their responsibilities will be as a part-time attorney within the firm, but yet an equity owner. Retirement, what it looks like after a set amount of years that they've been an equity owner or been with the firm, what that looks like as far as their ability to retire, and when that year is, and what the firm will pay them, and what they have to do with their membership interest. We put that all down on paper now.
Well, let's move to that. I want to quickly address two other events: disability and divorce. To outline on the front end that those are things that should be thought about, but they're really dealt with in a similar fashion the way death is, in the sense that it's an event you have to be aware of, and you need to plan for it in your operating agreement, your buy-sell. What that's gonna look like, in the event of a disability, what are you gonna need to help cover that person who maybe can't perform because of a disability or whatever else, whether that's obtaining insurance, like a disability insurance, like you obtained life insurance in the event of a death. And then divorce, understanding that you in the event of divorce, what's gonna happen to that interest, and protecting against it. So if there's anything you have to add to those, go ahead. But I know that we've thought through uniquely in our own business this idea about retirement and succession planning for that. So let's talk about, with the time we have left, what that looks like, and what would you recommend, business owners, real estate investors be thinking about in terms of their own retirement?
So first is, what does that look like? What does retirement for you look like? Are you going to want to play golf every day? Are you going to want to travel the world? Are you going to want to, spend time with your children and grandchildren? Or are you going to want to continue to work? Are you going to want to go maybe work for, something that you're passionate about versus something that, is making you money, right? What does that look like? I think that's important, is figuring out, okay, do I need a lump sum, or do I need amounts coming in on a regular basis? Do I need cash flow?
Yeah,
Or
and
do I
oftentimes what
yeah,
that looks like is a mixture
right,
of all
a
of those
mixture of
things.
all of
Yeah.
those, right? So I think just figuring out, what do you want to do, and what do the members want to do? And so, retirement can be as simple as creating some form of company 401k, or, there's like I think they're called SEPs or something like that
Sure.
for closely held companies that don't have employees. Once again, back to our firm and our growth and expansion, there came a point where, like, okay, we have employees. Um, and it's time to put a formal 401k in place. And, so that is one form of a retirement plan that business owners should look into, should deal with. We had to make changes to our company agreements, our policy and procedure manual, to reflect that benefit and what that would look like and how that operates. So that it could be as simple as that. But a lot of times, and I think you and I would both agree, while it's great, and, I trying to have that 401k be as large as possible, right? At the end of the day, though, that may not be sufficient. Um, uh, and because that may not be sufficient, I think you should look at your business as creating wealth for you, and creating the ability to provide for you in your retirement. So it could, a retirement provision or plan within an operating agreement or within the corporate documents, company documents, could be that the business that you no longer are required to work in the business, but the business is going to continue to make payments to you. Maybe you'll still be an equity owner of the company. You'll still be have your profit percentage, but you're not expected as an owner anymore to work in the business. Other people are going to step in, are going to operate, and then you just receive payments from the company, or maybe they're reduced payments. Maybe it's, okay, well, the profit is this, And you would normally be entitled to this, but we're going to reduce that a bit. Now, you and I both know, depending on the structure of the company, as far as the taxation goes, the tax structure, S corp versus C or versus partnership, S corp versus partnership, you may or may not be able to structure it that way as far as distributions go. But nevertheless, you have some amount, some percentage, some formula that you use to determine what payments the business is going to continue to make to that retired owner. Or it may involve the owner selling their membership interest back to the company, and the company has to purchase their membership interest, but with payments over time. So that's another, or maybe they're selling it to a third party and there's a provision in there, because a lot of times operating agreements say, well, you can't sell your membership interest unless we approve it. So maybe you have a provision in the operating agreement that says, okay, well, if you reach a certain age, you can, you have the right to retire. And if the company's not going to buy you out, then you have a right to find a third party that's going to take over your membership interest, step in, manage, participate in the management of the company, the operations of the company, and receive a percentage of the profits. And then you have your own side arrangement with them as far as what amount that they're going to pay you over time. That way, the way operating agreements are drafted are meant to protect the respective members, right?
Yes.
And so you draft them in such a way to provide that, hey, look, if you want to sell your membership interest, you can, but that person's an assignee, they don't get to participate, et cetera. Well, that's great and all until 20 years goes by and now one of the members is ready to retire and they can't, because they can't really do anything with their membership interest.
Yeah.
So you want to, on the front end, think about what does that look like and provide maybe an exception to that specific provision that allows for that owner to, purchase, but maybe reserving a right of first refusal for the company, whatever the case may be.
Yeah, as what we found as a firm is that, as attorneys, whether we're 40 or 80, we're attorneys. That's what we know how to do. And retirement doesn't necessarily mean I never want to see another law book again. It just means I don't want to do it as many hours as I was doing it, but I'd love to do it here or there. And there's a number of models, whether you're a lawyer or a real estate investor, that incentivizes you to still be part of things, bring business to the company, do those things and receive compensation for it, albeit just a little bit different when you're just running the show. So if you're at that stage, be thinking about that. Don't short yourself, because retirement's not that far away. It comes quick. With that, everybody, thanks so much for joining us today. That is our show. Remember, we will be at the Buy and Hold Meetup at the Scottsdale Area Association of Realtors this afternoon at 4 o'clock. Be there with us. We'd love to see you. With that, we'll see you all tonight or next week.
Have a good day, everyone.